I recognise the Honourable Trevor Mallard.
Thank you, Mr. Speaker. After all these years, Mr. Speaker, Labor supports the bill, and I do want to start off by thanking the Minister in charge of the bill for the cooperation over the last week or so as this has been progressed. I think it is an indication of Parliament working together in a way that it can, and I think it's only a pity that he was unable to be present on Tuesday and yesterday in order to take charge of the bill, because I think it's slightly lost a bit as a result of people who weren't quite as familiar with it taking care of it. And a note for the future is to make sure that the notes, when they are in his when a bill is in his name on the order paper, if not actually on the copy of the bill, to make sure that the member who's doing it for him says on behalf of the other minister, and then there wouldn't have been the confusion that was the case. And I think it's fair to say that the Honourable Nathan Guy was somewhat confused over a couple of days on this. And also, frankly, it would have been better if someone who was vaguely familiar with what was in it, rather than what's his name, Simon Bridges, who didn't appear to have any knowledge of the bill, taking it through the committee, and I think all I'm saying, it's a pity because it somewhat undid the good work that the minister did on the consultation and the work of the officials. I want to agree with the minister that the Law Commission did do a good job, and while I understand the reasoning for the government delaying this bill, I'm not sure that I agree with the logic. There have been a number of areas where it would have been better to have this sorted out earlier. I think in particular RENA, this sort of level of inquiry, I think, or one of the two inquiries that can be set up here, would be would have been a good approach for the RENA, and the ability to move more smoothly into the Fonterra and what might be now a wider inquiry, given Westland and some other things that we're hearing about the Chinese border, I think would have been useful as well. So I think one of the things we know is that if we could have got something into place in 2009, and if there needed to be some updates, it could have been done as part of an omnibus bill or a statutes amendment bill or something similar to get it tidied up. It would have been better to have in place. So I do want to compliment my colleague Annette King, whose sterling work it was to get this going, Rick Barker, who was prompt in getting the bill into the House and the Select Committee, which considered it well. I think it is worth doing a little bit of comment around the government supplementary order paper, because it is one that did make not major changes, but changes which were, I think they could be described as significant in the way the worked bill. What it does is it allows a bit more flexibility around the establishment of inquiries. And as an example, it allows the inquirer or the inquirers to be appointed before the terms of reference are finalised. And I think that is something which is useful because it means that their advice can be, they can effectively be on the job, and there can be some advice from them and some work with them around the terms of reference. And I think if anyone needs reminding of the importance of the quality of the terms of reference, one only needs to spend, as I did today, 10 minutes in the Privileges Committee listening to what happens when you have a poor terms of reference and an inquirer who was not properly involved in the development of the terms of reference, to know that getting that process right is something which is important and certainly didn't happen in that case, and this process can help with that. It clarifies the process for appointing counsel to assist the inquiry. I think it's fair to say that area was light. And it clarifies the discretion of an inquiry to manage its process and applying the principles of natural justice. And I think without going too far in the conversations that the Minister and I had over the weekend. I think it's fair to say that that was the area of greatest concern to the Labour opposition, the fact that there was effectively a loosening, a moving away from what had been established following the Erebus report and the Mann findings. And as someone who thinks that it is important that people who are being criticised have a real and a fair opportunity to answer and to have their views incorporated, I was concerned, as were some of my colleagues. But looking at it in the end, while there is a slight movement back, there is a balancing factor of being able to get a report done relatively quickly in some cases, because in some cases the findings are going to be quite important and are going to be needed for the development of policy or the application of resources or to avert a further disaster. And the last thing that you want is a highly legalistic litigant who is being criticised being able to hold up that process by way of reviews in the High Court and other actions. So there is it's like all of these justice issues. There is a balance that sits there. This is a slight tipping of the balance away from the fairness to the people who have been criticised towards the ability to get the inquiry done and dusted in a slightly quicker manner. But those rights still sit there. There's changes around the ability to recommence participants for their regional expenses without them having to be summoned. Previously it was sort of a weird situation where if you volunteered to come as an expert, you couldn't get your expenses. Whereas if you were sent for and required to come, you could, and that is really a silly situation. And I think the bill has sorted that out. Mr. Speaker, I also want to thank the government for accepting my amendment. One of the things, and this is no criticism of government at all, because it's not an area where there was any change on the part of the government around the question of people having orders restricting access to the inquiry, so either having private sessions or secret sessions. The very fact that some people come to inquiries is on occasions it is appropriate for that not to be made public. It's pretty rare, but the way that the bill was heading, it looked like it was a bit easier to do, and it was almost the inquiry could do it without thinking. So what we have done is make sure that sitting at the top of the matters that need consideration is the fact that the inquiry must take into account the benefits of observing the principle of open justice. So on balance, you don't go down that route, but if you do, there's some restrictions, and again there was a discussion about Nicholas' case and a number of others where earlier in the piece then it could well be appropriate, and in fact when Andrew Little forces Judith Collins to have the appropriate inquiry into the Rewa case, there could well be women who were raped by that man who would prefer and have the right to a secret hearing and a right to have their names never disclosed. My view is that that is absolutely appropriate. So, in summary, Mr. Speaker, this was a good bill. It should probably have been passed in a slightly less perfect form about 4 years ago, but Mr. Speaker, we've got to it now. It is better as a result of the changes, and it's something which I think has got widespread support. Thank you.
I call the honourable member Chris Okenvold.
Thank you, Mr. Speaker.
And I recognise him as well.